The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, should my trust be the beneficiary of my retirement account? So first let's talk about trusts and how they work. A revocable living trust is a really common part of a standard, normal, non-wealthy person's estate plan. Really, when a lot of people come to me and say, I need a will, often they really need a trust, and that's because what a trust can do that a will can't do is keep your assets out of probate. We want to avoid probate because probate can be expensive. It can take a while for your beneficiaries to get access to your assets. It can also be a big headache for your beneficiaries. So we avoid probate by transferring the bulk of our assets to ownership by a trust, and then any assets owned by the trust, and if there's a few enough assets outside of the trust when you pass away, all of those assets can be handled without a probate case, and hopefully a probate case won't be necessary at all. Your assets can be distributed immediately to your beneficiaries when you pass away if that's what the trust dictates. Otherwise, the trustee can kind of take over management of those assets until the trust requires them to be distributed. So it's a really good estate planning technique. The issue with retirement accounts is that retirement accounts are kind of unique in that they can avoid probate just by having a direct beneficiary that's alive at the time that you pass away named as the beneficiary of the account. So they don't have to be in the trust to avoid probate. There's reasons to transfer them to the trust, but there's also a lot of good reasons not to. One of the good reasons not to transfer a retirement account to a trust and just leave it in the name of direct beneficiaries is the ability to stretch out the required minimum distributions from the trust. So beneficiaries that are individuals as opposed to trusts can basically extend the number of years that they're able to allow the income or the principal of the retirement account to grow tax-free or tax-deferred, depending on what type of account it is, by stretching out the required minimum distributions, the amount that they're required to take out of the account over the course of their life expectancy. So this is a big tax advantage. It allows the assets in the account to continue to grow tax-deferred a lot longer than they would if you had the trust be the owner of the account as opposed to the beneficiary of the account as opposed to the individual. So for that reason, the general rule is that we don't want to name the trust as the beneficiary of the retirement account. If possible, we want to name individual beneficiaries that can take advantage of stretching out the required minimum distributions. Now, there are some reasons that it makes sense to forego that and to name the trust as the beneficiary. One is if you value having long-term control over how distributions are made and how the assets are invested over the tax benefits. So this might be if you have beneficiaries that you really don't trust to manage their own assets. Having the trust named as the beneficiary can solve that problem, but you have to value that over whatever tax benefit you'd get for naming the individual. Another reason, and probably more common, is if you have a complex beneficiary structure. So if you have a couple of kids that you want to split the account between after your spouse passes away, then it's really easy just to put that on the beneficiary form for the retirement account. But the beneficiary form for the retirement account might not be able to accommodate really complex distributions and contingencies. So if this happens, then this person's going to inherit. If it doesn't happen, then this other person's going to inherit. Or if you have a bunch of charitable purposes or multiple, 12 nieces and nephews that you want it to be distributed among. More complex beneficiary structures, if you value getting it to the right people over whatever tax benefits the people that get it are going to receive, then you may want to put it in the name of the trust. Also, ease of updating the account. If you have a lot of retirement accounts, putting it in the name of the trust will allow you to just update one document as opposed to 5 or 6 different accounts if your beneficiary designation changes. Now, this is similar to a complex beneficiary structure because generally if you have 1 or 2 kids and that's all you want to happen, there's not really a lot of chance that you're going to have to change the beneficiary designation. If you have a complex beneficiary structure and someone falls out of favor with you or something happens where you want to change that, then ease of updating that is another reason that you'd want it to be owned by the trust. Last thing we'll mention is there is a middle ground. There are see-through trusts that, if they meet certain legal requirements, and they're complicated and they're outside of the scope of what I want to talk about here, but if a trust meets certain requirements, then you can basically see through the trust to the beneficiaries and allow the beneficiaries to still take advantage of stretching out their required minimum distributions. So this can be a solution that you can work with your attorney on if you still want control over how the assets are distributed that the trust provides, but you want to take advantage of the tax consequences of having the account in the individual's name as opposed to in the trust name. There's a lot of room for error here, and it's not viable in all situations, and certainly in complex beneficiary structures it probably won't be viable. But there is a middle ground where you can have a trust take advantage of these stretch distribution provisions, and that's something that you should certainly talk to your attorney about. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube channel. If you found this helpful, please subscribe to us on YouTube, iTunes, and SoundCloud, and we'd love it if you leave a review. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We have offices all around Chicagoland for your convenience, and we offer free consultations in many areas of law. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.